The following is a conversation with Advocate Archie Bhatt. He is an advocate at Bombay High Court. He enrolled with the bar in the year 2017 after completing his law degree from the University of Mumbai. He possesses a qualification from National Committee of Accreditation and Federation of Law Societies of Canada. Currently, he is pursuing his master's degree in law with specialization in constitutional law from the University of Mumbai. Apart from that, his keen interest lies in information technology. According to him, during his early teen years, he used to tinker around with software and applications, which laid the foundation for his law degree, in which there is more place for creativity.
Record on this computer, recording in progress, live transcript. Yes, so we are live.
Yes.
Hello Archis, how are you?
I'm well. How are you, Manan?
I'm doing really good. So how was your week?
It was well. It was good. Every hearings before the High Court are going through video conferencing, so we are
So
at the comfort of our offices.
That's really great to hear. Great. You know, I had this question when I started doing law that what is the difference between the traditional 3-year law that people do after graduation, the 5-year integrated law, and what is the difference between the NLUs and other colleges that offer a law course?
So traditionally, the 3-year law program was common worldwide. Means everyone was going through the 3-year law course, and that was supposed to be a professional course after graduation. So after you completed your 3-year BCom, BSc or BA, people used to go for the LLB degree. And seeing that a year could be saved, they introduced the 5-year law program. But I would think that this is perfect for people who are sure that they want to switch to advocacy or into the legal field after completing their 12th exams.
Right.
But many of people who want to explore their horizons by saying that I want to become an accountant, or I want to see if I'm good at computers, they would first complete their graduate degrees in their respective fields, and then depending on the times and how their interests change, they can switch to law. And I feel that going for a traditional 3-year bachelor's degree in any other field gives you a better perspective when you switch to law, because you have experience in both the fields, in law when you are doing it, and also in the traditional 3-year bachelor's degree program. For me, I was a software programmer and I was also doing my BCom. So when I switched to LLB, it became easier for me to understand the law, because as a freelance programmer, my logical mind was already uh, it was helping me analyze the provisions of the law and how they apply in real world scenarios.
Right. So you already had the analytical part already in your mindset.
Yes,
You
yes.
didn't have
It
to
trains your mind
struggle.
to think that way. Yes.
Right, right. So you had a easy time doing law.
Yes. So as far as the 5-year law program now comes, it integrates these two degrees and saves you a year. But now this is a full-time program. So it is far more intensive and experience, and you really need to be dedicated from the very get-go that I really want to become a lawyer, or I really want any jobs in the legal sphere. So people opt for it. It saves a year. It is better in that sense. And when it comes to NLUs now, this helps you when it comes to securing a job in a top tier law firm. I would not say job, a retainership with a top tier law firm, or a good corporate a company which basically filters out applications that a person needs to graduate from an NLU. Otherwise, if you go before a court of law, no one is going to ask whether you graduated from a traditional law college or from an NLU. It never works out that way.
Right. So NLU, if if you had to explain it to a layman, what is the benefit of NLU? You would say that it helps the graduate get a job in a faster manner, and it on priority basis.
Yes, it does work out that way if you want a good package from a top tier law firm or a corporate, as I said earlier. And the very inception of these NLUs were to fine tune the research capabilities of certain institutions, as in universities, so that
Okay.
there is pure dedication towards this particular subject. Otherwise, in traditional universities, they are focused in all disciplines, including science, arts, as the case may be. Whereas here, they only focus on law. So, people who complete their degrees through NLUs, they are perceived to be better lawyers when they graduate, but that might not always be the case. But
Right.
that is why people prefer, oh, you have graduated from NLSIU. That is a top tier. I would say it has the first rank in all institutions when it comes to law
Institutions.
in India.
Right.
Yes. So you are deemed to be a brilliant child because you would not secure your admission otherwise. So
Yeah, that's understood. That adds
yes.
like it's an added asset that
Yes.
first it tells you that right from the beginning you had the dedication to pursue law, because 5-year courses can be pursued only after your 12th grade, and it
Yes.
also tells you that I was brilliant in both 10th and 12th standards. Right.
No,
So
they
as you,
don't really check that. They only check your CLAT scores. If you do well in your CLAT, you get admission.
okay, so they don't check. There is no relevance of 12th result. Only
If you
CLAT
are
score.
eligible for the CLAT examination and you do well in your CLATs,
Okay.
then you can secure admission in an NLU. I've
Okay.
had friends who did not have the best scores in their 12th standards, but yet they
Acha.
graduated from top tier NLUs.
Oh, okay. So only the CLAT is relevant to get into an NLA.
Yes, but I don't know whether this would be likely to change or not, but this is how it is right now.
Yeah. So as you said, when it comes to advocacy, or when it comes to a lawyer being fresh graduate or 3-year experience or 5-year experience in the court before the judge, you said that it does not matter whether you are from NLU or whether you are done traditional law. So what is necessary, I would say, that separates advocacy from the corporate law.
See, when it comes to corporate law firms or any form of corporate law practice, most of it is not exactly linked to litigation. It is more focused towards mergers and acquisitions, means contractual negotiations, and so on and so forth. So it has more to do with how you negotiate with the other party. And if there is a dispute, of course, it will lead to the High Court or the National Company Law Tribunal or other tribunals, as the case may be. But when it comes to pure litigation, everything has been done. So let us just visualize that there is a contractual dispute. Now you analyze what the dispute is and what evidence you lead. So at this juncture, it is on your expertise as a lawyer that how you structure your case before a court of law. And there they don't really check. What matters at this point is uh, whom you have joined, who your senior is, because if your senior has a good amount of cases, you have that exposure. No one is going to ask it kaun se law college se aaye ho. No one is going to ask. No one is going to be bothered with it. They are just bothered with how you perform in the court.
Right.
Whereas when it comes to corporate law, the hiring policies are there. You will not get a position if you don't fulfill the HR's dictates.
Right.
He will say, I want an NLU grad. You are not going to get considered if you are from a traditional law college. Though that is not always the case. If you have a rich experience in the past, you get considered. There are many people who are in top tier law firms, but they have come from traditional law colleges.
Okay. It is likely to say that when it comes to performing in the courts, your competence matters more than your tag that you have,
Yes.
right? Obviously, when if you look at even all the colleges, be it private colleges or be it traditional colleges or be it NLU, internships have always been an important part of a law course, and it is compulsory, if I'm not wrong. In
Yes, the Bar Council of India does have prescribed rules pertaining to internships, that you need
okay,
to train yourself as a lawyer to have that practical perspective, which is very much necessary before you secure a license to practice law. Many people don't do it, and in all means the practicality is that you get your license without fulfilling this practical criteria, because these law colleges, they have these practical subjects wherein you have to visit the courts, you
okay.
have to explain your experience in words, that this is how a matter was heard, how the judge
Mm-hmm.
decided the case, and so on and
Mm-hmm.
so forth. So that is, perhaps I think that is deemed to be compliance with this rule, but I don't think so. Every year for 1 month you need to intern under a lawyer or a law firm.
Acha. So
Yes.
if we'll just have a look at the section or the part that says that it is mandatory. Dev, can you pull that site up? Yes, right. Minimum period of internship. Each registered student shall have completed minimum of 12 weeks internship for 3 years course. So that is 3 months if I'm not wrong. So 1 month for
Mm,
each year.
yes, and that has
And
to be during the vacations. You cannot do it simultaneously during your lectures. You are supposed to
oh,
focus in the lectures. You cannot
okay.
just bunk your lectures and say that I am interning under a good lawyer.
Uh,
That is
yeah,
hardly an
yeah.
excuse.
Yes, yes, yes. So even the theory learning is also an equally important part of being a lawyer, no doubt about it. And 20 weeks in case of 5 year course. So that is 5 months for 5 years. So
Yes.
course stream during the entire period of legal studies under NGO, trial, appellate advocates, judiciary, legal authorities, legislature, parliament, and other legal functionaries. Okay, okay, okay. Hmm.
So after means,
So,
I would stress upon judicial internships. Many
mm-hmm.
people might not have heard of it, or they are very much nervous whether the judge would be willing to take us in for this particular experience. But
Right.
this is one of the best experiences a aspiring lawyer can have, especially
Yeah.
those who want to go to
Judiciary
those who want to become
preparation.
judges. Yes, those who want to become judges, they should approach a high court judge who's willing to take in interns.
Mm-hmm.
And there are opportunities in the Bombay High Court. You have to speak with the associate. You have to go to the you have to ask them whether the judge is accepting applications for internships, and if you are lucky, you will be considered, and for one, at least for 1 month, you get that experience.
You can,
And
yes.
yes.
As far as I remember, my seniors and other few friends, because we share the building with NMIMS College of Law. I knew a few friends who did under internship under Kathawala. So
Yes.
Justice Kathawala does offer internship to students, and even the interview experiences, he was being very kind and very cordial and warm in his interactions while asking the questions to the students. That is what I have heard. Now I also wanted to go last June. I had talked to one of my friends who had already interned with Kathawala, Justice Kathawala, and I wanted to see, but then again, this Corona situation happened and everything went off the charts. Right.
Yes, Justice Kathawala is indeed very gracious when it comes to accepting interns.
Yes.
So, given the opportunity, everyone should seize it, because there is tremendous learning experience under them.
Yes.
So, That
And
being said, even I think tribunals might be giving these opportunities. You can, if you do not get a chance to intern in the high court, you should also consider various tribunals for internship
okay.
opportunities. But I have not checked whether that really happens or not.
See, when now, since we are talking about internships, one of another important part or an ancillary part of this discussion has always been stipend. That whether to take up paid internships, or is it okay to do unpaid internships. So what would you suggest in your opinion, that and if there is any legal opinion also, that the bar council says that it is mandatory to pay some stipend. What is your take on the stipend case?
See, notwithstanding any rules or any particular requirement by the bar council, I personally think that as an intern, you are a liability. I'll be very honest with you. You are
Okay.
not really going to help your senior structure a case, because he is going to teach you how to structure a case, how to appear before a court.
Hmm.
So it is more or less like you are gaining something from your senior. So if there is a case where you are getting an opportunity with a good senior but you are not getting a pay, you should definitely accept it. I would
Hmm.
not say that you should insist upon getting some stipend or not, but there are many
Yes,
cases where,
there are. Yes, there
yes,
might be lawyers who might be, in taking advantage of this also. That even if they don't have, sufficient number of cases, or they don't have such an established practice, yet they exploit the interns who want to learn. Yes, there is no doubt about it.
see, I personally think that those who pay their interns, they should be appreciated. Of course, I'm not going to
Yeah.
resist myself from commenting on this, because let us just address the elephant in the room. As you rightly said, people want,
Uh,
I would say, the lesser known advocates, they want interns to hold their papers. But then again, we as advocates are under the obligation to train the juniors. So
right.
we are basically providing something to you in kind. And it and if that advocate has a good name, you are most likely going to use their names in your resume,
Yes,
and
yes,
that
yes. It is
resume
like
will carry a lot of weight more than that stipend.
definitely,
So
definitely that.
yes, we cannot always say that I'm not getting paid, this senior is not good. That can never be said. But we are not going to reject the opportunities where certain seniors who are not as well settled as other advocates, who just hire interns to
Carry
carry
papers
their
around, right?
papers. Yes, yes. But let us just address the positive side of it.
Yes. But as students in law school, law college, or even the fresh graduates, see, moot court is a very important part of the curriculum.
Yes.
And what is the difference that you would point out between a moot court that is being taught in colleges and universities and the real life court scenarios?
I was fairly active in moot courts when I was a law student. So I would say that there is light and day difference between a moot court and what happens in real courts.
Whoa.
But with that being said, I will never discard the importance of moot courts, because generally, if you happen to participate in a national moot court competition and you make it to the finals, most likely a sitting high court judge or a retired high court judge will be looking into your case. Means how well you argue before him, how well you address his questions. That will be taken into consideration. So I would say that the moot court competitions are a brilliant way of building your confidence as a lawyer. Nothing more than that. Because in moot
Hmm.
courts, your drafting is key. How well you draft the memorials. That is hardly the way people draft petitions and plaints and all other forms of legal pleadings. We stress upon the facts, whereas here you stress upon the issues. It depends on the case at hand. Most of the moot courts are focused towards stages, that so and so SLP has been filed before a Supreme Court of India. The matter is set for final hearing. You have to structure your you have to structure your memorial accordingly. Whereas in
Hmm.
trial courts, that is hardly the case. The drafting is completely different. So you will not end up being shocked. Oh, I had done so much in moot courts and now I don't know anything about the real world. Whereas in my initial days, after reading the pleadings and petitions and the way they are being drafted, I found it easier to transition into uh, real world practice. And the
Okay.
confidence that I had gained because of the moot courts, I did not shake or fumble before a judge. That was the biggest takeaway from moot courts.
Wow. So that is, truly remarkable that, as a fresh graduate, you are saying that you weren't trembling before or, shivering before the judge of the court. That's remarkable.
I think anyone who is into moot courts, they will be able to manage before a real court. But you just need to know that they some though I will this opinion of mine will not be appreciated by law colleges. They stress upon pandering to the judge, which is not always the case. That you may your lord first you start with your lordship. May I approach the dais? You must have heard of it.
Yeah.
That's the
Okay. Okay.
very
Okay.
first. Yes, that's the very first thing you're supposed to do. So that is never being done in high courts. Never being done in
Okay.
any court of law. If you do it, you will be wasting the court's time. You are supposed to end your arguments in a matter of minutes. And if
Right.
you spend your time with all such pleasantries, the judge will just say that you make your point and leave.
Whoa.
But that being said, you are supposed to be respectful. You are supposed to address the court as per the court's decorum. So you have to maintain that balance.
So just like you said, that in a moot court, that there is a pandering that you have to address the judge as your lordship or your ladyship.
So that is there in the real courts as well, but not to the
Okay.
degree that we do in moot courts.
Acha, acha, okay.
Uh, uh,
That is, so you have to be respectful enough, and at the same time not be very casual also about it.
yes.
Yeah. So Archis, you are practicing advocate at the Bombay High Court, and you are pursuing LLM in constitutional law.
Yes.
What is it that as a person, as a student of constitutional law, that that the layman does not understand about the constitution, and why is it that an ordinary person has criticism towards the constitution of India?
See, uh, I will start my answer by by explaining my life as a student in secondary school.
No,
We had the
definitely you can
subject
start
of
it
civics.
anyway.
We
Uh,
had the subject of civics.
right.
There we were not taught anything about constitution. I don't know what is the curriculum right now, but in the SSC board, we learned very little about the constitution. We did not
Right.
know what our rights were as citizens of this country, or let us just say as residents of this country. That the very basic human rights we enjoy. We were never taught that. We were basically taught the structure of the government. That is it.
Hmm.
So after graduating with my BCom degree, I was completely unaware on what the constitution says. We only had the basics of it, and that hardly does it for anyone in this country.
Right.
Once I completed my LLB, I came to know how important this fundamental law of this country is, and how important it is for everyone, not just lawyers, to know what the constitution is. And that is not being taught till the bachelor's level. So this being said, we the biggest one of the biggest reasons why we citizens of country are unaware about our rights is that legal education is not a part of the school curriculum, which is basically covered under Article 21A, which is mandatory in nature. The government is supposed to look after our education, but they have not, I would say, they have not bothered to incorporate this important subject in our curriculum.
And I think, I see school, I there are always students who study from the uh, purpose of achieving marks. And even if that was the case, that civics was given some weightage to the paper, and it said that it is necessary to study, then yet do you think that the marks, that the weightage allotted to civic subject would make a difference if it was given in school?
I think that is perhaps one of the most important subjects in the school curriculum, and especially from what I have learned, it was treated as an optional subject. Means we
Definitely.
used to focus on history and geography.
Geography,
Civics
right?
was like something we used to do at the end of the day, at the 11th hour.
I
Okay, you
think,
secure 10 marks from this.
yeah. So it's like, I am from an ICSE school. Okay, so I guess this is a blanket experience to students, that the section of the civics subject in the notebook was always like the 30% of the notebook, that we would divide
Yes,
the notebook 70% into history and 30% into civics. So
yes,
that reflects the attitude also, that we are allocating such an important subject so little importance at a grassroots level.
yes. You can almost imagine that if they incorporate the constitution in the curriculum, the kind of awareness the youth of India will have, and how much responsible the government will be for its inactions. And I am not commenting on any parties, but
Yes.
this kind of accountability would be difficult for a government to have, because everyone will be raising questions. No one will be pleading ignorance. The constitution is drafted in such a way that it singly is capable of means bringing in awareness for everyone who goes through it. And that's how I really appreciated this subject, and that's why I chose it for my LLM, because I want to progress further in this subject. And I really, one of my goals is to bring about more awareness on this subject in the youth of before the
In
youth
the
of India.
constitution.
Yes, yes.
Right.
So they are more aware about their rights, and so I hope
Mhm.
hopefully I've answered your query.
Yeah, so do you think that making a constitution in an integral part across all the streams also, be it science or commerce and arts, what possible impact it could have if it was made compulsory until the graduation level, irrespective of whether you are pursuing law after 12th or not?
Hmm. So assuming we are talking about BSc degree, wherein you
Okay.
are incorporating this particular subject, it might not be entirely relevant, but having some sort of essence in the degree would in the degree course would be relevant, in the sense that there are provisions in the constitution where we are supposed to take care of the environment, we are supposed to take care of the living beings, including animals. So if there is a relevant course which speaks about about the environment, such provisions of the law would be very
Hmm.
much necessary to be imparted in the student's mind, so that when they progress further in their careers, they are far more conscious about the environmental impacts that
Hmm.
their projects in hand will carry.
Yes.
Yes.
Yes. So I
So
guess what curriculum can be, shifted, I mean, constructed in a way that, uh, let's say you said about BSc. So BSc, what is important? The impact on environment, IPR is important. So those parts of the law that are relevant to the particular stream, maybe only that part could be incorporated in the
yes,
curriculum and maybe made useful to the students.
yes. See, I think the essence of the constitution needs to be taught till the 12th standard, and bachelor degrees are focused towards respective fields. So we
Hmm.
cannot just replicate the entire, means teach the entire constitution in a BSc course. It will not make sense. This would be a funny
Right.
idea, to be honest. But
Yes.
yes, I think that the relevant laws, as you rightly said, that let us say if you are doing the MBBS course, they are taught medical ethics, the code of ethics regulations, and all the
Right.
applicable law for their practice, so that they are aware that what they are going to do in their professional life is ethical or not. So that is
Right.
already there in the programs.
Correct. See, when I entered the field of law in 2018, see, I always had this question that how can a lawyer defend a person who is already guilty? And I was wondering that doesn't it conflict with the idea of justice itself? And there is also a video of Ram Jethmalani that speaks on a similar topic. Dev, can you pull up that video?
Committed this offense.
So restart the video. Yes. Yeah. Play.
Now, for example, your client tells you that I have committed this offense. That doesn't give you a reason for refusing to defend him. People ask that question, that why? Why does a lawyer have to defend a person who tells him that I am guilty? The reason that a lawyer can very legitimately advance is that it is society which has made a rule that nobody should be convicted or punished without adequate convincing evidence. When you argue a case for a person who has told you in private that he has committed the offense, what you are telling the court is not, you are not swearing on oath that I know that my client is innocent. You don't have to do anything of that, and that's professional misconduct. What you are telling the court is that the evidence on which my client is being convicted does not satisfy the standard which you have laid down for everybody. You point out the defects in the evidence and leave it to the judge to decide.
Stop sharing. So Arjis, what see, with due respect to senior advocate Ram Jethmalani and his opinion, what is your take on such? Because this is a common dilemma that a lawyer or a young lawyer might be facing, or a young law student might be facing.
So with all due respect to Jethmalani sir, the legal position is that, I would not just say legal position, the ethical position is that in an adversarial system, you need competent representation from both sides to arrive at the correct factual position, so that the judge is completely empowered to understand, okay, this is the fact, these are the facts, and as per the law, this will be the outcome of the case. So if, let us just say that an advocate is approached and the client has admitted his guilt before him, that okay, I have committed murder. Now, as an advocate, you are ethically bound to lead all evidences which are relevant to the case, and you are not supposed to hide any facts or not hide any evidence which would be relevant, which would show guilt of your client. You are supposed to protect him with all the available defenses under the law, but you are not supposed to, let us just say, you hide the murder weapon. You are not supposed to facilitate that kind of practice, because that would be highly illegal and unethical. You are supposed to give all evidences and then say, okay, your honor, this is how the facts clearly show that this is not, that my client has not committed the offense of murder. Then you are supposed to explain. You cannot just say that there is no evidence, and you at the in your chambers you have hidden all pieces of evidence, so that the courts are waylaid into arriving at a different outcome. So that is not permissible, and that is highly unethical. But that being said, declining representation to your client just because he has admitted his guilt is contrary to the principles of justice, because the very basic principle of natural justice is audi alteram partem, let the other side be heard. And in modern day scenario where the complexity of laws are so much that a common man can hardly understand it, they will just say that I have committed murder, but do they understand the defenses available to him? They don't. So for that they need capable representation, and for this you need a lawyer to represent you. And if you have the entire bar declining representation, then you are basically making a mockery of the justice system. You are deprived of injustice. It is a travesty of justice. So therefore I would say that as lawyers, as Jetmalani sir rightly said, you cannot say no to your clients.
So it is always it is for the foundation of the thought is that despite the fact that your client has, confessed to his or her respective advocate that I have committed a crime, your moral compass should not come in the picture to discharge a duty.
Yes.
Moral compass aside.
The moral compass should only be geared towards coming with clean hands. You need to come with clean hands before a court of law. You cannot hide any facts. That's it.
Right. Also, with such cases, I when I was in the first year of law, and it was I think in the law in the classroom or for during the moot court or something, I got to know that the jury system that is prevalent in US law structure, it is not prevalent in India. And why it is not prevalent is because it's about that case
KM
about that
Nanavati.
KM Nanavati wala case. So can you put some light on that why was jury abolished after that case, and why is it still prevalent in US?
See, in the jury system, I might be completely wrong at this, because I am not exactly a criminal lawyer. But the thing is, when it comes to the jury system in the US, they have managed to uh, carve out a good process whereby you are supposed to appoint an impartial jury. So there is an elaborate screening process through which you are able to ascertain whether a jury member is clear from all kinds of bias towards the accused or not. If he has bias towards the accused, he is not appointed as a jury, he is discharged.
So when you say bias towards the person, so you mean to say that the close relative or any person who has the interest in the case will not be appointed as the jury or a jury, right?
Those are definitely the factors, but this also delves into your thought process. For example, this might be quite controversial. Suppose there is a hate crime against the black community, and a jury member admits that I myself am a black person, and therefore I am biased towards this subject matter.
Okay.
Therefore, the judge will discharge you. The accused will be deprived of a fair trial because you are clearly having this notion that if a hate crime is committed, the person has to be given a guilty verdict. So you need to be truly impartial. You need to approach the matter. You need to approach the facts of the case with an impartial view. That is the essence of a jury trial. And I personally think that this particular system is not being used in India right now, is perhaps because the screening process must not be being established in India in that sense, because In the US, the practical way of screening the jury is far more effective, and probably there might be practical hurdles in India.
Might be,
And
maybe some hurdles that we aren't
so
aware of.
I'll definitely plead a great degree of ignorance in this matter. But the thing is,
Okay.
here legal, I would say the degrees of legal education certainly has a role to play. And there is a great amount of partiality when it comes to, let us just say, sexual offenses. There is a great level of hatred towards the accused.
Yes.
You would require a person who is experienced in dealing with such matters, and that is most likely a judge.
Right. So yeah, coming back to your field again of constitutional law, our constitution was drafted by taking bits and pieces of constitution of other countries. So in a simplified way, we can say that our constitution is a concise, constitution, or an amalgamation of all the famous constitutions of the world. Yet, there is always this criticism about the constitution, that the constitution is biased or it is not well drafted. Because what happened is, and this is my personal experience also, when I talk to non-law friends, they always have this mocking opinion, or a cynical opinion towards the constitutions, that अरे constitutions तो कुछ करता नहीं है, इसलिए तो कोर्ट में इतने सारे cases pending है, judiciary is lousy, it is lazy, not doing its job. In those areas the opinion is. So as you, as a constitutional lawyer, or a student of constitutional law, what would be your answer on such a same situation, or what is the base reality and which is not known to the public for constitution?
See, I'm hardly calling myself a constitutional lawyer. I have a long way to go for that.
Okay.
So, having said that, I can definitely admit to a few things, that the massive perception behind the judiciary's backlog is because of the population. I would say India is a populous country. We are suffering from population explosion, and due to the pending issue of vacancies within the judiciary, you are going to have judges who are overburdened with casework. So there will always be a scenario whereby many people are deprived of justice because of inordinate delays. And having considered this fact, there are many amendments, such as the Commercial Courts Act, whereby civil trials have been expedited. So now, when I say civil trials, I would say commercial matters as a facet of civil law.
Just
So
to
it is now seen as a third sphere of the law itself, but it comes within the sphere of civil law, as per my understanding.
Excuse me to interrupt. But what do you mean by inordinate delays?
Inordinate delays would be as in, let us just say a suit is filed before a court of law. So as per order 8 of CPC, you are supposed to file your written statement within 30 days of service of summons. That can be extended till 90 days out of the discretion of the judge. You have to give reason for the delay. But in ordinary civil cases, which are not commercial matters, the delay, there can be delays of months or even longer, where the written statement is not filed, and without a written statement, you have a case before the court. Since of course you have certain other remedies, but for this, the court has powers under section 151 of CPC to condone the delay given sufficient cause. So such cases are, I would say, there are a huge number of cases where there is lethargy on part of lawyers also. They don't file the written statements. They keep on taking dates. I would not entirely shift the burden on the judiciary that they are responsible for delays. I would also accuse the advocates that many of them, they delay the trial just so that the parties negotiate the settle the matter. This is one of the main reasons why there are delays. They want the parties to settle the matter out of court. And given this scenario, the public perception is
It's quite
quite much
blurry.
against the courts. Okay, the courts are responsible for the delays, but no.
Hmm.
If the lawyers, they diligently handle the proceedings, they file the written statement in time, they cross examine the witnesses, they do everything in time, you will the matter will get sorted fairly quickly, though it might still be subject to delays. And given the COVID-19 pandemic, you cannot expect your matter to arrive at an end within a gap of months or something which.
Speaking of COVID-19 pandemic, the lockdown began in last March 2020. Until then, the courts were open, physically open, and the lawyers had to go to the courts. So how has the COVID-19 pandemic affected the way advocates can function? Has it become easier for the advocates to handle multiple matters at the same time? And is it more efficient to continue this virtual hearing system even after the situations, even after the situation is improving?
Now, it is a known fact that we are going through troubled times, and these are unprecedented times. And courts of law can be fairly crowded, so it is very much expected from the courts to resort to virtual hearings, so that there is minimal chances of transmission of the virus. So that being said, virtual hearings will continue for a while, because this also makes it easy for the advocates to appear in matters and not bear the risk of missing out on a hearing just because you are in a different. You can just, after ending your arguments, you save the time of traveling to that court by clicking on a link. So that saves precious time of the courts as well. They don't have to adjourn the matters. You can attend multiple hearings. So there is a positive flip side to this particular issue. So virtual hearings, when if the infrastructure is developed in a way that would make it effective for the courts of law to administer justice to matters, then I am completely in support of this. Though I would say that there are different stages, and in stages of evidence where a witness has to depose before a court in the witness box, there you need to have physical hearings. And this is a known fact that they don't resort to virtual hearings during such stages.
So I guess this is again my personal opinion, with the criticism that the judiciary receives, that it has a lot of backlog. What this is again my imaginary situation. I don't know if it can be implemented, and I don't know the outcome of it. But looking at how the courts have been functioning in the past 1 year, what I think is, yes, the virtual hearing should continue, and just like you said, the trial part of the criminal law should take place physically, and not to completely shift the office from work from home. But what we can do is that the advocates can continue to sit in their office and attend the hearing within their office only. So even that, because I think that if we completely switch to work from home, it is going to impact the mindset of of any person, because we are a social being. So staying alone or staying constrained in the house, or only restricting our movement to only a few limited areas, is going to impact us a lot.
We will definitely be going through some difficult stages to adapt to this particular new form of litigation. But I don't think it will be long enough for it to become obstruction. Definitely in rural areas where internet connectivity is an issue, this will be a long battle for them to conquer. So having
Yes.
said that, there have been deliberations by constitutional courts where they want to set up facilitation centers so that access of justice is not a problem for rural areas.
I understand. Even apart from the functioning of the court also, see, I appeared for my last semester in June, right? So the entire last year of my law course was online. And if I'm not wrong, your initial stages of masters also would be online only.
Yes.
Yes. So how is it that the way the education is imparted or the way the tests have been taken in the past 1 year? Is it going to affect the quality of education imparted in the students that will be graduating with such system?
See, the bar, when it comes to LLB, the Bar Council of India has prohibited distance education because the brick and mortar institutes are alone capable of giving that interactive experience of debates. Now, though this is possible in an online mode, uh, it doesn't give you the same experience a physical classroom will give you.
Yes,
And that
definitely.
kind of, I would say that kind of human interaction is very much required in subjects like law, medicine, and all other practical subjects whereby you need some physical interaction. Now, having said that, learning of the law in that way is easy. It can be done online. I might not have the most popular opinion right now, but it can be done online because even the courts have shifted to online hearings, as we just discussed. So, given the right approach of imparting legal education through online classes, I think we can adapt and in an effective manner. Even moot courts can be done online. And this way, when we graduate from law schools, we will be far more competent in dealing with virtual hearings.
Yeah,
Because
that
yes, because we have interacted with the class with the faculty in that way, so
right.
interacting with judges also becomes easier.
Yes, yeah, this is a really good point that you brought up. See, because we don't know how long this situation is going to last. So it is, beneficial that right from the first year, that we inculcate this habit of virtual hearing. This is a very good point.
Yes.
Yes. See, even in this, the imparting of the education was also online, and the exams were also conducted online. So this is my now, since I appeared for the last semester only, the exam format was changed. Okay, so the exam format was brought down to 60 marks from 100 marks, and it was 50% MCQ and 50% a 2 line to 3 marks question. Okay, so is this, and there was also a debate, there is always a debate of how open book test should be, brought in the curriculum, particularly in the field of law. So, what do you think is the benefit of, is there a benefit or is there not a benefit of bringing such a system of marking, like the MCQ format or the open book test, or you would like to stick to the traditional format of question answers that the university has been conducting so far?
Okay, so I'll take some time in answering this question
Yes,
because
yes, you
one of
can
the biggest
break the
yeah,
question also.
because one of the biggest criticisms that I have for the Indian legal education system is that it is heavily relying upon rote learning. That you are supposed to memorize the case laws and all the sections, and you're supposed to reproduce that on a piece of paper. That is
Yes.
fine if you want to create machines. And now I'll be drawing my opinion along the lines of Three Idiots. But that is how it is. If you want to create lawyers, you need to create critical thinkers. You need to create people. You need to develop their creative thinking abilities. That has to be the focus when it comes to the LLB degree and other law programs.
Right.
So I see, I have a legal education in Canada, and the exams that I had given were open book. So
Oh.
what we were given were case studies. We were given a set of facts, and the questions were along the lines of, now you are supposed to give a legal opinion to your client. What will you do? Now you are a federal court judge. You are supposed to give a judgment on the facts of the case. What will you do? You are supposed to write a judgment in that answer. So this is how I think is the optimal way of approaching legal education. And having said this, we automatically disregard MCQs. MCQs are easy to do because you get a correct answer. And if you have read the subject, acing your multiple choice questions is not difficult unless it is scenario based. So I would stress upon the need for scenario based and multiple choice questions, whereby a case is structured and there are 10 multiple choice questions which are supposed to answer.
Yes,
So that would
be
basically,
yeah,
yes.
that would be a great amalgamation and a test of the thinking ability, because see, both the patterns that we are talking about, has their own default. So when we bring in the situational from one side and we bring in the MCQ from the other side and make it into one format, that will give that will take the thorough test of knowledge, also reading skills, and how quickly can lawyers solve a problem.
Yes. So having said that, in a court of law, they don't really check your memory. You basically
Yes.
carry the bare act with you. You carry the petition copy with you. You actually read out the entire, means the relevant portions of the petition and the judgments before the court. You are not going to recite the judgment from your memory. Your lordship, I recall this judgment where so and so view was given. You are easily going to come up with a flawed argument because you are going to forget a relevant portion of it.
Right.
So this particular system of rote learning will not help you become a good lawyer. It will only show that, okay, we have good machines who have great memories. They know the section. Oh, Article 21 says that you cannot be deprived of your liberty. Okay, that's fine, but it goes way beyond that. So that, for that, open book learning is very much required. You need to know how to analyze that book. You can't just say, okay, page number 30 has this, has mentioned a right to life. No. How do you interpret that particular portion of that subject? That is to be tested by a college.
Right. So, the Archie's now, see, this has been taking place, this situation that I'm going to narrate has been taking place since the boom of YouTube, I would say, YouTube or any other platform like Netflix or Amazon Prime. See, what is happening is initially, and I would also say that I was also a part of it, that the series, the content that is being put up on such platforms, okay, Amazon Prime, Netflix, now it has a prototype background that there has to be violence, there has to be profanity, there has to be the use of heavy curse words in Hindi, in English, and there has to be other parts that aren't supposed to be watched by people under 18. And so do you think that the OTT and or a censorship is going to help, or the artists are going to find some or the other loophole in the such in the law, and they are going to still continue to build such content only?
See,
I mean,
This
even you
particular,
might have noticed that that the recent series, or not to name any series in particular, but this has the common background of violence, nudity, cigarettes, and drinking at an early age, drugs, and everything.
see, this particular argument is a double-edged sword. We are
Hmm.
basically deciding between creative freedom
Hmm.
and public morality. Now, my personal opinion would be to strike a balance, and that can be done by appropriate legislation. Right now, we have the intermediaries guidelines
Hmm.
that has come up with a capable of mechanism, but
Hmm.
that does act as a blockade for producers to come up with content, because it automatically gets categorized as per the levels of violence or nudity that which they might feature in their
Hmm.
programs. So so it does help. It does get in the way of commercialization of such content, and therefore, when it comes to OTT platforms, which are earlier heavily complete, they were not subject to any regulations as such. Matlab, these are sought to be regulated. It
Hmm.
does get into the way of how your content gets published. Now, Netflix, for example, they do have a child-friendly mode. You have that profile,
Ha,
which
right,
is
right. Kids
okay,
profile, yeah.
wherein all that adult-only material or adult-only series, they are completely taken out of that particular profile. But then
Hmm.
again, we have tech-savvy children who will
You will
know their
switch the
way outside it.
profiles.
Yes,
Yes, yes.
they it is as easy as going on Google and searching for that material. Oh, Sacred Games is there on. I cannot see that particular series. Now I'll just search on Google and try to download that episode. So it is,
Right.
the menace will always be that despite the legislation being in place where you try to regulate the content, it will just get into the way of creative freedom, because uh, if you try to regulate it too much, you'll be cutting essential bits of content. Now,
Hmm.
if your show is thriving upon violence, which at points of time are the realities in certain parts of the world,
Yes.
you will be basically restricting creative freedom, which is basically guaranteed under the constitution and I would say any fundamental laws of any country.
Hmm.
And that should not be the bar, because people who have developed that maturity, such as adults, we can we can easily go watch that material and enjoy it.
Yes, we can
But for
easily
children,
differentiate, right?
for, as far as the safeguards against children is concerned, what we can do is we can create such profiles. We can categorize it as per children only material, as in, so this, the biggest flip side to this is that the producers
Hmm.
are a bit skeptical on the kind of content that they will be able to show, because earlier this particular category was subject to parental discretion, and now there will be media companies who will be stressing ki, okay, we'll only show this material for a
Hmm.
specific category because we want everyone to watch it. So that gets into the way of the producer's mindset ki, okay, I want to show all material, and the media company is not, they do not want to show it. So there is a
Yes.
lot of differences between them.
Hmm. 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 Hmm.
So this is
Yes, yes.
completely means we are seeking the government is seeking opinions on this. So let us see the outcome of the new amendment to the Cinematograph Act,
Hmm.
and then we can discuss it further.
Yes, yeah, that is true. See, even as you see, the way artists need to have that, voice that brings out the, absurdities on any topics, whatever they take up. And by restricting or by telling that they, or by disallowing them to not do, we will not be pushing the limits of our own knowledge. See, because we know something, okay, but we don't know everything. But when you talk to some ex-person, say a stand-up comedian or an actor or person who has worked in any series or any movies, they might bring a different perspective as to why such things are being promoted, or why these things are necessary to be shown. just like you said, realities are always there. We cannot have a blind eye that women are still being raped in some part of the country.
Yes.
If it's to be shown, it is to be shown. Yeah, and I guess even at a micro level, if you see, it is also the parents' duty to supervise at least that what the children are consuming. You cannot leave a 6-year-old or a 10-year-old with a Netflix account and give access to watch whatever you want to watch. Maybe
Yes.
there can be some instructions given that as a listen, there are definitely a few content that you cannot watch at this age, but at after some age you can watch, and when you have the maturity to watch it. So the person has the autonomy to differentiate between what is entertainment, between what is reality, and what is being shown is merely for the sake of mockery.
Yes. And having said this, I think our constitution in that way is quite modern. It respects the freedom of speech. Now the government cannot curb dissent or an opposing view just because it falls into the category of violence or it falls into the category of nudity, because sometimes
Hmm.
that can become essential for portraying the hard realities. And now having a blanket ban on such subjects, you will be
Hmm.
basically impinging upon their freedoms of speech.
Right.
So a delicate balance has to be established, and uh,
Hmm.
I think this becomes very complicated when it comes to having appropriate guidelines enforced, because at the end of the day it is on the parents to guide their children on how they are stopped from getting access to such kind of content which they are clearly not mature enough to access.
Correct.
But then again, the modern generations, the current day generations, they are capable enough of
Yeah.
bypassing all loopholes. They can easily download such content illegally.
Right.
So that is the hard reality. Let us just face it.
Yes, yes. I mean, both the sides, be it the artistic side or the OTT platforms, and be it the people, who are complaining that such content cannot be shown to the public for morality purpose. Both the sides have equal amount of responsibility in in if from the fact, I mean, with respect to their own side. So if you say a person is saying that, okay, this is morally not good to show in public, they also have the responsibility to teach amongst themselves that, okay, we won't watch this part. Okay, let them create and we won't watch. And at the same time, even the content creators shouldn't cross, uh, a boundary or show and take undue advantage of their artistic freedom also.
So yes, and one more point I would like to add is
Right, right. And that's a fair argument to say in every way possible. So Archis, uh, thank you for giving us your time and imparting your own personal opinion and the legal opinion as well. We really appreciate that you showed faith in us by being the first guest today.
thank you.
And now I'll be stopping the recording.